Hi, good afternoon, everyone, and welcome back to the session on the second session on land law. Now, we're going to be continuing on our discussions in order to look at, the learning outcome 2. I'm just going to quickly switch over to the unit specification. And in the unit specification, we've covered the basic details about how to understand, the nature of interest in real property. And here we looked at, legal and equitable interests. We also looked at differentiating between personal and proprietary interest. We looked at different forms of licenses and ownership, which can be granted under, some sort of agreements. Specifically, when we talked about, different types of licenses, and licenses could be for royalty, for example, for taking benefits. And in some cases, when we talked about the example of tenancy, we talked about, how the ownership and the title of ownership, slightly differ in some cases when you look at, the way the benefits are classified, even though you might be the owner, but when you rent out a property under the tenancy agreements, the benefits of the property can be then utilized by the tenant for the duration for which, the tenancy agreement has been signed. We also looked at various types of leases, freehold leases and ground leases. We talked about, how they differ from license and how does licensing and lease, what are the key differences between them. Now, in learning outcome 2, we are going to be looking at, dwelling into things which the learning outcome talks about, which is estoppel. So we look at this particular term, which will come across time and again during this particular discussion. And estoppel will essentially be the principle which precludes, a person from asserting something contrary to what is implied by a previous action or a statement of that person, and in some cases, or by previous pertinent, judicial determination. So if it has been to the court of law, we will look at basically understanding how and under what circumstances, the concept and the application of estoppel is to be done specifically in learning outcome 2. And in literal terms, when we talk about, we're going to be looking at understanding this from a point of view of, estoppel, which is basically a legal principle. And that prevents, if I talk about literally in terms of what does this do, it prevents someone from arguing something or in some cases asserting certain rights that contradict to what they previously said or have been agreed in law. And in those cases, you would look at that people would basically use this concept and apply estoppel so that they are not being unjustly wronged by inconsistencies of another person's word or actions. And the whole learning outcome 2 will essentially revolve around that. So we are going to be looking at 3 or 4 assessment criteria, 2.1, 2.2, 2.3, which is the first one is going to be looking at establishing, what is the meaning of estoppel, and we will in detail look at proprietary estoppel. The second one will talk about analyzing the conditions for the creation of estoppel. How does it get created, and under what circumstances, this can be invoked. Then we'll also look at some of the remedies which are available when estoppel is, invoked, or when the, legal principle of estoppel is applied. How do we look at some of the remedies? This will take us back to contract law, when in broad sense, we'll be talking about the 5 different types of remedies which are available, and how those of them that we have discovered and, talked about in contract law will actually be related to the principle of estoppel. And then in the merit criteria 2.1, we are looking at examining a presumption. So we need to be looking at what is a presumption first in law, and obviously how presumption of innocence or presumptions of reliance, there are different types. We will be looking at talking about that, and then the idea would be to try and examine that with the help of a case. And there are lots of different cases that we will go through when we discuss the principle of estoppel specifically in this learning outcome. Now, in order to discuss this, as always, I've created, a PowerPoint presentation. We'll be going through some slides in this particular, discussion that we do today. There are going to be a lot of case references that we will need to do, and they will be based around, estoppel case studies, essentially estoppel, We'll be looking at presumptions. We'll be looking at, remedies. And the idea would be to try and give you links through the, PowerPoint presentation, wherein you'll be able to look at case summaries, wherein it allows you to establish and understand the meaning in a bit more detail by understanding how this is applied, what are the cases which led to the creation of the principle of estoppel, and how we differentiate and invoke these when we look at obviously somebody. When I say somebody, I mean a business or a person trying to gain unjustly, or by looking at wrong, unjustly creating or committing wrong by inconsistencies from the actions or words of another person or another business. So in general, this is the indicative content that we are looking at. So we're going to be focused on understanding what is the meaning of estoppel. We'll be focused specifically on proprietary estoppel, different types. And then under that particular part, we'll also study the presumptions and, what are the principles of presumptions. We'll also be looking at, understanding what are the various remedies and what are the distinctions between different types of proprietary estoppel. We'll look at estoppel and its types. There are 4 in general. And then we'll talk about remedies and how these remedies can be used or can be based on reliance cost, and how they can be used essentially to fulfill expectations of both parties which have invoked or are involved in estoppel. So let's start off with the key terminology. Look at 2 or 3 key terms that are going to be a part and parcel of this particular learning outcome, and they would be, looking at understanding what is estoppel, what are remedies, and then we'll start getting into some of the, assessment criteria. Now, when we talk about, estoppel, estoppel it's a legal principle that prevents somebody from arguing something or asserting a right that contradicts what they previously said or has been agreed in law. So in some cases, it is meant to prevent people from unjustly doing or creating wrong or creating inconsistencies in other person's words or actions. Now, a simple example of this literally would be to understand, if, say, for example, a particular person like Donna, for example, has obtained judgment in the court for, say, for example, custody of the child, Leroy, and then after the judgment has been passed, they are then sued for child support. So in this case, Leroy would be collaterally stopped basically from claiming that he isn't his father. So if the father and the, for example, in this case, the mother get into a bit of wrangling, and then the case lands up in court for the purposes of, custody of the child. And if the court grants the custody of the child to, say, for example, the father, and then if this is prevented, if the mother, in this case, Donna, for example, prevents or, sues him for child support, whereas the custody of the child is essentially with the father, then in this case, the father is collaterally stopped from claiming that he isn't the father because he is paying all the child expenses. Now, there are other examples of, how we look at, estoppel. So if we look at, some of the other examples of estoppel, one such clear example that we could look at, comes across when we consider, for example, going back to what we were discussing yesterday, real estate, and what is the state of land. And, when we talk about estate in general, what we will generally see is that a document, which is basically created that when you sign a tenancy agreement or you license or lease out a property to tenants or, to businesses or individuals. And in those cases, the documents which are required to be generated in order to ensure that, you own the property or you are basically leasing it out, the transaction is legally valid and obviously it's being rented out. In this case, the agreement which ensues, say, for example, the rental agreement, the amount of the rent, the duration of the tenancy, and the amount of security deposit or the expiration of the agreement. Now, these conditions, when they are included, in the agreement, they would basically form what is called, an agreement which has been signed by the tenant and the landlord. Now, if either of the, parties basically prevent the other in carrying out their basic responsibilities or go back on their word, or their actions essentially, mean that in some cases, that would mean that they would unjustly be, let's say, not be able to use the property. So in those cases, they will be looking at applying the estoppel principle, and in such cases, the court of law would essentially allow, collateral damages, or, say, for example, let's say issues which arise, then the court would be looking at, solving them. Now, when we talk about, say, for example, the purpose of estoppel, we could look at, if we understand, say, why this is applied, it normally would, in a situation wherein there are two parties in a contract, a purchaser and a seller, you would generally see that the purpose of estoppel statement would be, or an agreement would be such, in this case, the estoppel principle would be applied, because in some cases you would see, the prospective purchaser, or in this case, the lender is about to lease the premises, and the other is that when they are leasing the premises, there's a contract or a formal agreement being done. And the other reason would be to give the assurance that, the purchaser or the lender was actually leasing the property, as an example, would be, not making any claims at a later date for any inconsistencies which have been, put into the contract or have been created because of the contract. So the idea there, core idea being that, the idea of creating documentation, and that documentation basically removes inconsistencies for both parties, and it as a legal principle, prevents either party from either arguing or asserting certain rights which have not been included in the agreement or contradict the agreement. And this is this is agreed in principle in law, and that would allow people from either party, or in this case, people from being unjustly wronged by inconsistencies of words or statements or actions of the other person. Now, when we talk about estoppel, we also look at what is, basically proprietary estoppel. So when we talk about proprietary estoppel, what we really get to see in terms of the literal meaning of this particular term would be that, essentially someone is given a clear assurance that they will acquire something over a point in time. If we assume property, for example, then what we would want to basically look at is that if this let's say the rights of the user property which has been leased out, or for example has been given to the person, in this case, if they see that there is a dispute which arises in the future, then in those cases, you would be essentially looking at proprietary estoppel. So this would then become a legal claim, which is basically established and it is connected to English legal law, which would arise when, in a situation wherein the right to use the property of the owner may be prevented, and this would create basically some sort of dispute between the transfer of ownership, and that is where we will get to see that it tends to be that a proprietary estoppel or a proprietary estoppel tends to be applied. So in most cases, when we talk about, say, for example, proprietary estoppel, in a nutshell, what I would basically say is that when a claim is based on the fact that where land or property is usually, say, for example, a farm, a piece of land, then in such cases, should a claimant, be concerned that, this has been given to them or has been given to them, under certain reasons, like a promise has been made that this farm or this land would be, ultimately given to you, or in some cases, if there is a reliance that there was a promise which was made in terms of making sure that some of these choices, when would be made, the land will actually be given to you, or the farm would be given to you. And in some cases, what you would generally see, if the claimant has been working on the farm or on the land during its lifetime and for little or no payment, if they are going to be deterred from taking ownership of that land, then in those cases you would generally see a proprietary estoppel would apply. Now, what I would want to do is basically play a quick small video before we get into more details, is to look at how this concept of proprietary estoppel is established, and when somebody is deceased, for example, when somebody passes away, then in those cases you would generally see, in order to honor the promises which have been made, this would mean that with the use of the proprietary estoppel, the right of ownership would be transferred over to that particular person. So let's listen into this particular video, which basically would explain, the concept of proprietary estoppel. So I hope you're able to see the screen. Let me play this video now.
Is a claim whereby you thought you would is.
Let me start this again.
Proprietary estoppel is a claim whereby you thought you were going to inherit from a parent or grandparent, and unfortunately it comes to pass that you don't actually receive as it was intended. So you may have, for example, worked on the farm from a young age and you've devoted all of your time to the farm and you've not been paid for your time. And if you have done that and it's been to your detriment, then there may be a claim arising if you've relied on the promise. If the promise that has been made to you has then caused you to be in a worse position that you might have been otherwise, then you might consider whether or not you have a claim. You need to be able to show that the promise that was made to you was clear and to be able to show what it related to. But if you can do that and also show that that has put you in a worse position, then it may be worth exploring whether or not you have a claim for what is known as proprietary estoppel.
So I hope, this video has given you, in short, a clear idea in terms of what is proprietary estoppel, and we will get into this in a bit more detail as we go along in terms of, our discussion. Now, the other bit that I want to cover in key terminology is basically remedies. Now, when we talk about remedies and remedies from a point of view of, remedies in law, then we are going to be basically looking at, in a literal sense, meaning that sometimes when a wrong is done and in order to correct that, or if there is a contract and there is a breach of contract, then in those cases, the legal right resulting from some sort of a civil action, lawsuit, or some sort of a judgment in the court of law, then determines basically, what you are going to be getting as damages, and that would be basically, classed as remedy. So when sometimes you hear about things that, so and so went, were taken to court, and when the court judgment was passed, the judge awarded, damages or ordered particular type of action or an injunction, essentially to support the judgment. And that is where you will see that they will be classed as what are called remedies. Now, there are various forms of remedies. We'll get into them in a bit more detail, but just at this stage, remedy would be, different types, and they would include things like damages, repudiation, recession. You'll have specific performance, injunctions, and restitutory, awards. Now, the main reason that you have to keep in mind is the primary purpose of damages in contract law is to essentially place the party which is injured or has lost out in a position that they would not have, they would have been in if the contract had been performed. So, for example, a simple example of a remedy would be that, say, for example, if a dispute arises between the tenant and the landlord is actually losing out on rent because the tenant has lost his job and he's unable to pay the rent, then in those cases, if the landlord takes the tenant to the court, and the court would then award a series of go through the proceedings and obviously award the landlord the rent to be paid, and this could be paid from the proceeds of maybe the tenant's holdings, assets, and things like that in dire cases, and in some cases would put some sort of a timeline to ensure that the rent is brought in line. Otherwise, the landlord would be given right to, say, for example, evict the tenant in this case, and that could be one form of an example of remedy which the landlord would maybe look at if the tenants do not pay rent over a period of time, and it leads into the court of law. Now, with this, let's get into some of the assessment criteria to understand, the bits which are covered in this learning outcome. So the first one talks about establishing or explaining, essentially, explaining the meaning of proprietary estoppel. Now, as I've explained in that particular video, proprietary estoppel tends to be a legal claim, which is especially connected to land, and in the English legal system, this may arise in relation to rights to use the property of the owner, and in some cases may even be effective in connection with disputed transfers of ownership. Now, in order for the proprietary estoppel to be established, or in this case, the right of transfers can happen if the following conditions are met. So someone is given a clear assurance that they will acquire this property if the person is deceased or has been written out in the will. They reasonably rely on this assurance, and they are then acting substantially to make sure that their detriment is, they basically are able to, they are deriving income essentially from such, say, land, and this is their strength of assurance. And last but not the least, it would be unconscionable to basically have them go back on their assurance, because this would be providing the primary subsistence for them in some cases, for the purposes of, living. Now, if these elements of assurance and reliance and detriment and unconscionability are present, then you would generally see the usual remedy would be that the property will be transferred to the claimant, and in the court views, the reliance to warrant, would rest in terms of certain circumstances, if otherwise proved from the 4 conditions which are given above. Now, one of the cases which basically led to the creation of, proprietary estoppel was Wilmot and Barmer. And in this case, J. Fry, the judge, considered 5 elements which were established before this proprietary estoppel could operate. And in those cases, he put these across, as these 5 conditions. And in this case, they were basically the claimant must have made a mistake as to his legal rights. It had to be proven that the claimant must have done some sort of act of reliance. That means they would have had to show that they are reliant on that particular piece of land. The defendant, in this case, the possessor of the legal right, must know of the existence of its own rights, and which is inconsistent with the right claimed by the claimant. So they should be, in line that if you are the legal owner of the land or the farm, you should be aware of your rights. And in some cases, excuse me, when you talk about the defendant must know of the claimant's mistaken belief that, you are under presumption, or you are under some sort of false presumption that this is your land, even though the ownership of the land is with somebody else, but you're actually using the land to derive benefits from it, and your presumption is that you own this land, although you don't have the title of ownership. Now, this particular case, basically forms the, let's say, the foundation of proprietary estoppel. Now, when we talk about, how this has been applied in the modern case or in the 21st century, you would normally see that this, along with the decision, judgment which was passed in the High Court in the case versus Walton Stores versus Maher, what the judge actually recognized that both principles of proprietary and promissory estoppel encompass the broader principle of equitable estoppel. So when we talk about different types of estoppels in the next, learning outcomes, we will basically establish what are the various types, and how they are then different from each other, and obviously how they apply in certain cases when we talk about wrong being done or inconsistencies being found either through actions or words of the claimant oblique defendant. So this task is simple enough, wherein you have to explain the meaning of proprietary estoppel, and maybe a use of a case just as an example would help kind of convincingly complete this particular task. Now, the second part basically talks about the conditions that we need to understand through which estoppel as a legality arises. Now, when we talk about, as I mentioned to you earlier, the principle of, estoppel in English law essentially, is clearly defined, because it is under certain conditions that it prevents person from relying on certain rights or upon certain facts. And these are different from the facts which have been either discussed between parties or have been stated on an agreement. Now, a situation where an estoppel would arise would be when you would see creditors informing debtors that debt is forgiven, but later they will insist that we want the repayments of the debt to be done. So this is a very good example of, sometimes you would see if you work with or take out, say, a bank overdraft, and or maybe you take out a loan from somebody that you know, and in your discussions, the person or the business which is known to you basically says, okay, we will forego the interest, on the loan interest that you are incurring on the loan repayments, but at a later stage they basically serve you notice to say, okay, we also need the interest on the loan amount to be paid. Now, in those cases, you would see that this principle or the doctrine of estoppel would get established. Now, you would generally see that there are different types of estoppels. There are estoppels which are created by misrepresentation, or basically by representation. You will look at contractual estoppel, promissory estoppel, and also proprietary estoppel. Now, this is where I like to add and bring this into from a point of view of what the modern approach was when we look at the judgment in the High Court in the Walton Stores versus Maher. This is where the different types of estoppels were essentially established by the Judge J. Oliver. Now, he restated that the broad approach, when we look at in some of the cases which have been, let's say, fundamentally involved in creating this modern approach, it basically comes to the fact that when we look at some of these cases of Walton Stores versus Maher, we look at Taylor's Fashion versus Liverpool Victoria, and we look at Habib Bank versus Habib Bank Zurich, we basically get to see that this led to the creation of what are the modern approaches of the principles of estoppel. Now, how they are established in terms of under the remit of proprietary estoppel, we look at that there are three conditions which need to be met. First is an assurance giving rise to an expectation that claimant would have an interest in land needs to be established. Second would be the claimant must demonstrate that they are reliant on the income or some sort of benefit being generated from the land. And that is where, this has to be demonstrable. The third is the claimant must have acted to their detriment as a result of assurance. That means if in some cases it has been assured that this is an income that you'll be able to derive from the land, and if that is taken away, then this becomes a detriment for the claimant, and that has to be proven in order for the proprietary estoppel to be established. So let's look at some of these in a bit more detail. So when we talk about these three conditions, let's start with the assurance. Now, an assurance can be of different types. It could be active or passive. And an active assurance essentially would be, that wherein you can actually, from a point of view of definition, and so in this case, if I just do a quick enter here to differentiate. So an active assurance can be by words or by conduct of the owner, and this can lead to the claimant believing that they have interest in the property, or in this case, a land, house, whatever it is. And an active expressed assurance can be looked at when we talk about certain cases like Pascoe versus Turner, we talk about Griffith versus Williams, we talk about Gillette versus Holt. And in those cases, we get to see that an active assurance has been established because the owner has given his word to the claimant that they would be getting the benefits, from this particular land. Now, an active assurance can also be assured by conduct, which can be seen in different cases like Inward versus Baker. The second type of assurance that we see is passive assurance. Now, a passive assurance is wherein the claimant is mistakenly having an expectation that they would be gaining an interest or they would gain from this, piece of land or the property. And in this case, the owner stands by and does nothing to change that belief. So if I have a property and say, for example, if we talk about a case wherein a property is being rented out between two brothers or two friends, or in this case, the elder brother rents out his home to the younger brother, and what will happen is the younger brother is under the pretext and expects that, this is basically an assurance given by his elder brother that he could actually stay in the property free of cost without paying any rent. But what the elder brother does is continues to provide that assurance and does not do away or claim, tell him that you are mistaken in this case. And that is where the passive assurance is given. Although at a later stage, they may, when I say they, the elder brother may claim rent from the younger brother. So there are several cases which basically establish this. And one of the ones that we can look at versus Shaw versus Applegate or Scottish versus Newcastle PLC, Scottish and Newcastle PLC versus Lancashire Motor, a mortgage corp. Now, assurance can also be, given apart from active and passive. They must be clear and unambiguous. They also need this. In some cases, assurances provided may not be strictly enforced, and in some cases, assurances which are given can be questionable because in those cases, the assurances given are irrevocable. So if there are assurances given within the family or within businesses or for long-term purposes, you would generally see that these assurances, in some cases could be irrevocable. So we need to be aware that when we talk about assurances, which is the first part that needs to be established in proprietary estoppel, we talk about active and passive, and then be able to differentiate between active and passive assurances, which can lead to the creation of, proprietary estoppel. Now, the second would be reliance. The second point that we discussed when we talked about, how proprietary estoppel can be established is that the claimant must demonstrate reliance on the assurance. So in this case, when we talk about the claimant being able to prove that they are reliant on this piece of land or the income from this piece of land, and that is where the estoppel then can be established. So there are different cases which basically talk about this, and these cases, could be Attorney General of Hong Kong versus Humphreys Estate. But if you look at back home, Evans versus HSBC Trust, and they basically highlight the reliance on the assurance. Now, the third part that we look at essentially is the detriment or change of position. So when we look at, in some cases, the claimant acts to their detriment, that means, so when we talk about, the claimant must have acted to their detriment as a result of the assurance, that in those cases, that also needs to be established that yes, if the claimant has essentially, assumed that there is an income that is going to be derived or the benefits which are going to be derived from the land, and then they are basically done away with. So that would cause detriment to the claimant, and in this case, significantly change their position. And there are several cases which, kind of highlight this as a third point, which is required for the establishment of, equity for proprietary estoppel. Now, in this particular task, what we are also looking at is understanding, some of the other aspects, which is how does the, claimant establish equity? So how do they satisfy equity? So equity, once it is been established by the claimant, the court then assesses the appropriate remedy for the, damage or remedy which can be awarded to the claimant. And in this case, when we talk about, the remedy, we talk about different types of remedies that we're going to take up in the next assessment criteria. And they would be basically looking at injunction, awarding, repudiation, recession, performance awards, and also in some case, damages in general, when we use the term, that they would be provided to the claimant once his equity has been established. So in general, there are a few cases which basically look at how equity can be established in proprietary estoppel, and we need to be looking at one or two cases to understand. For example, there is a case in point for compensation. There is a case in point for occupational rights. There is a law that we can look at, which is primarily looking at conveyance of freehold, leasing, and you could pick out one particular example to establish how proprietary estoppel is basically established. So that would basically cover, the second task, which looks at analyzing the conditions which lead to the creation of proprietary estoppel. So three conditions which have to be met: the different types of estoppel and how it relates to the modern approach, which basically, look at these three conditions of assurance, reliance on the assurance, and detriment or change of position to the of the claimant, and that helps in satisfying or establishing equity, and that leads to the creation of what is called the proprietary estoppel. Now, the third assessment criteria that we are looking at is primarily examining what are the remedies available. Now, if I just briefly refresh and talk about what are the remedies. Remedies basically tend to be legal rights which result from a successful, say, civil lawsuit. In some cases, the judgments which are passed in the court of law, and the court decides or determines that these individual rights in specific situations need to, they establish that who is right and who is wrong. And in turn, what they do is they establish charges or damages which are to be then provided to the claimant or the defendant or the person who basically gets the, wins or, gets that judgment in their favor. And that is where you would generally see remedies being awarded. So when we talk about, damages in contract law, they are basically legal remedies available in case if the, contracts are not fulfilled or breach of contracts occur. And these damages can be awarded, as I mentioned earlier, in the form of remedies. And these damages could be in the form of money to compensate the other party. It could be damages which are primarily provided as injunction, as repudiation, in some cases, looking at recession, and in some cases, even specific performance and restitutionary awards. And they will all be covered under this particular assessment criteria of 2.3, looking at examining the available remedies. Now, so when we talk about damages, under the head of damages, we look at examining a lot of different types of damages which can be covered under contract law. So when we talk about these include things like loss of bargaining, reliance, discomfort, disappointment, inconvenience, diminution in general. When we talk about, your the prospects of future, essentially get diminished. So when we talk about diminution, your business prospects would be diminished if, for example, a competition has, copied your product or your product design. So what you could do is take them to the court of law and under that claim for damages, because that would reduce or diminish the future prospects of your organization, deriving revenues from there. And then sometimes you also look at speculative damages and liquidated damages. So we talk about damages being a broad head, and under that there are different types. So let's look at some broader types which are established and are related to when we talk about different remedies available. So one could be reliance loss, the second could be discomfort or disappointment, the third could be inconvenience, the other ones could be diminution of future prospects, and then these speculative charges. So I've briefly defined most of these from a point of view of looking at least a few case summaries that you can look at, and they will allow you to maybe when you read the case summary, they will allow you to understand how it was a reliance loss, or how it has caused discomfort and disappointment, and in some cases inconvenience. So the first remedy which is normally available tends to be damages. The second one that we look at is repudiation. Now, I don't know in terms of if you know the meaning of the word repudiation. Anybody in terms of the meaning of the word repudiation? So repudiation basically is rejection or of a proposal or an idea. So in some cases in the court of law, when we talk about repudiation, we look at basically the denial of truth or of validity of something. So sometimes you would see damages or let's say remedies are also provided in the form of repudiation, because this tends to be looking at leading to a breach of contract. And repudiation involves bringing an end to a contract. So essentially when people land up in the court and they look at one of the ways through which this can be resolved, and if it is going to be repudiation, then it basically looks at bringing the contract to an end. So if a party is not able to make payments, or for example, in some cases, if you're a landlord and your tenant is not able to make payments of 1 month rent, second month rent, what you would do is basically repudiate the tenancy agreement, and that is what would mean is you'll bring the contract or the tenancy agreement to a abrupt end, wherein you would not be looking at giving any notice or anything of that which would be normally there in the agreement, because of the fact that you are going to look at seeking damages under the clause of repudiation, because there's a breach of contract. So there are a number of examples that we look at which will help you understand repudiation, and you could look at one of these versus Bettany versus Guy or Posades versus Spear, and the case summaries would help you understand why and how repudiation typically tends to happen. That means you refuse to accept a liability, and in some cases you reject the validity of, say, for example, proof, and then or you reject or say that it is untrue. What you're trying to do is basically repudiate a charge or refuse to acknowledge or refuse to pay a debt, and that would be covered under one form of damages. Now, the other tends to be rescission. Now, rescission, if we talk about, in terms of, let's say, rescission, if we talk about in terms of law, and in general, when we talk about, the meaning of the word rescission, you generally see that, when we talk about rescission, literally the word would mean revocation or cancellation or repealing a law or an order or an agreement. Now, when we talk about rescission in law, you're generally going to be seeing that when we say rescission, it also means to a certain extent cancellation of a contract. So rescission may be unilateral, or it could be when a party rightfully cancels a contract because the other party is breaching or creating a material breach in the contract. And rescission in some cases can also be mutual when both the contracting parties agree to disagree to remaining, obligations that are required to be covered in the contract. So sometimes you would see that rescission is also, available when a contract is voidable or results into a void contract. And in some cases, you would see that this voiding of contract could be done on the basis of misrepresentation, undue influence, or duress. And sometimes you would see that the third party or the party involved in this case, when I say both the parties, would like to rescind, the contract, and that is where they would normally say the third party acquires the goods, rights to those goods through the lapses of time, and where the principle of restitution in integrum is not possible. So there are a few cases that are put essentially here, which basically would allow you to understand, where rescission could essentially be applied, and that would be, the best way to look at another form of damages, which basically can be claimed under, proprietary estoppel. Now, the meaning of the word restitutio in integrum essentially means that you're going to restore, the contract. So essentially, you're going to restore the injured party to a situation wherein they would have had the usual delivery of goods when this particular, let's say, disruption would have not happened. So sometimes, in the literal meaning of the word, you would normally see in this case, this would in law terms mean restoring it to a pre-contractual position or putting things back, the way they were, is basically, the use of this word restitutio in integrum. This originally comes from Roman law, which allows the party to be able to restore, against, what was supposed to be what was supposedly promised. And in this case, if a party is allowed to rescind, then you would normally see that at some stage they will be asked to look at the effect of restitution integrum, which is basically meaning that they are required to put things back the way they were. And the idea would be to look at, understanding this through one of the cases that are listed on the slide. Then we also talk about damages, which basically include specific performance. Now, specific performance in terms of, when we talk about equitable remedy. So when I talk about, equitable remedy in law, what we generally mean by that, is that when I talk about equitable remedy for specific, let's look at the general meaning of the word equitable remedy. So here, the basic, bit is that this particular damage or this particular remedy is the practice of granting, what is called compensation for the inadequacies which have, come about because of the breach of contract. So in this case, the inadequacies, which the court awards, so basically at the discretion of the judge, they could not grant, say, for example, say in this case, for example, if the breach of contract has happened, then the order from the court requires one party to basically perform their contractual, obligations. That means they have to specifically look at completing the performance of that particular contract. Now, whilst there would be, difficulties or possibilities that the contract, one of the party which is required to fulfill the contract may not be in a condition or a position to do it, but the court would put specific guidelines and terms and conditions in place so that the other party, if they are reluctant to or they are unwilling to basically perform the contract, then this can be specified in the judgment at the discretion of the judge, that specific performance has to be related to the fulfilling of some of these contractual obligations, which basically would be applying in the case of the contract between the two parties. So when we talk about the degree of specific performance, this is one of the most important equitable remedies, because here the focus is primarily on ensuring that the contractual obligations are actually performed. And if it is the court which basically directs or gives the order to someone who's a party to the contract to instruct them to perform their obligations under the contract, and refusal to observe these terms of the order is basically considered in contempt of the court. So there are various circumstances in which specific performance as one of the remedies can be applied, and then they are covered under things like when damages are inadequately covered. There could be different types of contracts. There could be hardships in delivering the contract, and those are all covered with certain examples of case summaries here, which you can read for more detail. The last one that we talk about in terms of damages or remedies is injunctions. Now, injunctions are another form of equitable remedy, wherein you would see normally, some sort of compensation or judgment, can be made available or basically complied on at the discretion of the judge. So in this case, there could be three different types. It could be interlocutory or interim injunction. It could be prohibitory, and it could be mandatory. Now, these injunctions, when they are applied, essentially, so when we talk about, in general about, say, injunctions, and we talk about the meaning of the word injunction literally, you would generally see that this is a court order which essentially prohibits a person from taking a particular action. And in this case, that will be termed as prohibitory injunction, or in some cases, it requires them to take a particular action. That means they have to do this, and that is a mandatory injunction. And in some cases, you would see interim or a temporary or an interlocutory injunction, which would mean that this is usually granted pending a further hearing or until a full trial of the case or the breach of contract tends to happen within the court. So when we talk about these injunctions, they tend to be very important forms of damages or remedies which can be applied. And they could be three different types: interlocutory, temporary, or interim, as whichever way you call it, prohibitory, and then there are mandatory. And these then are applied, I've given specific examples of three different cases. So mandatory injunction, prohibitory injunction, and, partial or interim injunctions. And you could read some of these cases to understand, basically the case summaries to understand where and how they are applicable. So any questions on this so far, please feel free to ask me through the chat route, or, stop me and I can, answer. Happy to take your questions or queries. Now, the last one that we talk about in terms of, the assessment criteria is the merit one, which talks about the use of presumptions of reliance. So when we talk about presumptions, what we want to do is first we want to look at what do I mean and what is the importance of presumption. So what I would basically say is that when we talk about, let's say, start with the meaning of the word, presumption, because presumptions could be for various many things. It could be for innocence, regularity, it could be for death, it could be for denial, it could be for sin, different types of presumptions could be applied in the case of law. But literally starting with what is presumption? Presumption basically would be an idea that is taken to be true on the basis of probability. So if I look at the literal meaning of the word and I talk about presumption, literal meaning of the word presumption would essentially mean that an idea that is taken to be true on the basis of its probability. And that would be, the meaning of the word presumption. So let me just put this down in the speaker notes for the purposes of clarity. Now, when we talk about, presumption and meaning of the word presumption in terms of, law, So when we hear presumption could be, having various connotations. So we could talk in terms of word, death, law, innocence, constitutionality, guilt, regularity, advancement, fact, lots of different things. But general, if I look at the general legal inference that we would apply in most cases, would be that, when we look at the legal inference that must be made in light of certain facts. So presumption is an idea that is taken to be true and on the basis of probability. So it would be that also that they are taken in the light of certain facts. Now, when presumptions are basically looked at or, are made, they can sometimes be rejected. They can be proven as false. And in some cases, they could be thrown out, out of the court of law when proceedings are happening because there is insufficient evidence or it creates sufficient doubt in the minds of jury or the judge, and they might create suspicion or insufficient, basically create distortion in terms of the evidence being presented in the court of law. So when we talk about presumptions, one of the presumptions that we talk about, that we basically say that which is let me get into it with the fact that when we talk about presumption in terms of evidence or in terms of presumption in law for evidence. So when we talk about that, what we mean by that is that in some cases a particular fact can be made without the aid of any let's say statements or any particular data which can back that up. And in those cases, what you would say is in the law of evidence, a presumption of a particular fact can be made without the aid of proof in some situations. Now, the invocation of presumption shifts the burden of proof from one party to the opposing party in the court of trial. And when we talk about presumptions, there are general two different types. And the first type is rebuttable presumption, and the other one is, conclusive, presumption. So when we talk about rebuttable presumption, it is assumed true until a person proves it otherwise. That means, in this case, until unless you prove your innocence, until unless you prove, say, for example, in the court of law with evidence, this would be termed as what is called rebuttable presumption. Now, in contrast, the other type, which is conclusive presumption, tends to be that facts could be refuted in any case, provided evidence is available or is provided. So when we talk about conclusive presumptions in general, we would basically look at things like, in some cases, the proof of certain facts makes the existence of assumed fact disputable. So in this case, the presumption cannot be rebutted or contradicted by the evidence to the contrary. For example, if I give you a literal example, in some cases, when you look at, in the court of law, it would be said that, a child younger than the age of, say, a certain age is presumed to be incapable of committing a felony. So in those cases, when you look at the conclusive presumptions, you will generally see that law cannot be rebutted by evidence and must be taken to the case whatever the evidence to the contrary. So these are bits that we have to look at specifically when we talk about, presumptions. Now, what is the relevance of, say, for example, presumptions? So if I talk about the relevance of presumptions, or examples through which we can talk about what, we mean by, say, conclusive presumption and by, rebuttable presumption, what we are basically looking at is, in conclusive presumptions, you are basically looking at that one can disprove the given facts because they are either fictitious or they do not exist. So in the case of conclusive presumptions, sometimes you would see that, a case in point that I would say is normally when you look at, sexual charges or rape charges, essentially what you would see is in the case of such crime being committed, a minor is incapable of providing consent. So in those cases, it will be conclusive presumption that a wrong has occurred. And there is no argument here because that claim that a minor could not consent, is not going to be simply true. So we will need to look at examining the presumptions as a broad definition under the law, and here the idea would be to relate it to different, relate it to the two types, which is rebuttal and the conclusive presumption, and use an example to examine the importance of presumptions when it comes to the legality of cases, or in some cases, when we talk about that the evidence and conclusion and proof has to be let's say performed on the basis of the evidence that is presented. So in those cases, I would suggest that when we look at a meaningful conclusion being made either because of existence or non-existence of a fact that may be drawn from either from some evidence and admitted, and then it's proven to be true, is something that we need to examine as the principle of presumption. And this needs to be done through the route of taking an example, both in the case of rebuttable presumption and one example to explain under the case of conclusive presumption, and that would help us complete this particular task. So today's session, this is where I would probably end today's session, because the idea is we've covered comprehensively all the assessment criteria. We've looked at what is, the principle of estoppel or doctrine of estoppel. We've looked at the various different types of estoppel, when they arise, what are the remedies available or damages which can be provided when they do arise, and it has to be settled in the court of law. And last but not the least, we've also examined what are these remedies in a bit more detail, and then the role of presumption, which basically, allows, let's say the conclusive facts to be established under the, in presumption of, through rebuttable and conclusive presumptions, the two different types, is what we need to be covering in this particular, learning outcome. So any questions or any doubts, feel free to raise them now. And if you would want to go through the lecture and the presentation that is up available on Moodle, there are some case laws and case summaries which you'll be able to find as Word documents to do some further reading. There are case studies that have uploaded onto the Moodle, which primarily include the principles and the various cases related to how estoppel was established, the modern approach, and last but not the least, looking at some of the bits which are related to the assessment criteria. So presumptions in terms of there's a case study or a handout which is primarily from the Cornell Law Review. There is one which is a theoretical paper if you want to get into understanding what is a presumption of reliance. And then we talk about the presumption and the law of evidence. And there is case study which is primarily related to promissory estoppel and the reasonable reliance, and then one which is related to the basis of how presumptions are used in the court of law when we talk about the doctrine of estoppel. So if there are no more questions, I'd like to end this session here, and thanks very much for joining, and I'll catch up with you in the next session next week. Thank you. Bye for now.